Hi, good morning. Today we're going to be looking over the case Downs v. Bidwell for our justice review. So, to give some background of the case, the U.S. was expanding and gaining territories, but in regard to certain territories such as Puerto Rico and the Philippines, the government did not assume that these territories would be treated as the other territories were treated. Downs imported oranges from Puerto Rico and sued the New York collector of duties for imposing higher duties on these oranges. Downs argued that Puerto Rico was part of the U.S., so higher duties violated the Article 1 under Section 8, saying that all duties imposed and exercises shall be uniform throughout the United States. This was Downwell was one of the insular cases. It was one of the cases that confirmed the right of the federal government to place tariffs on goods entering the U.S. from U.S. territories on the grounds that the Constitution does not follow the flag. Now, this was just one of the many cases, but it did establish that the Constitution did not follow the flag in this instance. But usually the court would rule that the Constitution would follow the flag in Puerto Rico. It wouldn't apply the same in the Philippines. So the issue before the court was, does Puerto Rico qualify as a territory, and does Article 1, Section 8 apply? The decision was that no, the revenue clauses in the Constitution extend only to states, not to the U.S. territories. Nothing in the Constitution indicates its applicability to territories. Language in the 13th and 14th Amendment demonstrate that there are places to subject the U.S. jurisdiction, but that are not considered part of the United States itself. Previous legislation dealing with the Louisiana Territory presumed that the territory was not subject to Article 1, Section 9 of the Constitution, and Congress enacted specific legislation making the Constitution applicable to the Louisiana Territory, unlike with the Philippines and with Puerto Rico in this case, demonstrating that it was not presumed to be able to apply by virtue of being a U.S. territory. Now, although the Supreme Court previous decisions have been inconsistent on this subject, the Constitution does not automatically apply to acquired territories in its entirety. Now, in the dissent, they wrote an opinion which can be viewed today as what a normal judge or how the Supreme Court would usually interpret, given that today we are way more liberal than we were back then. In the dissent, they wrote that because previous decisions of the Supreme Court have held that 14th Amendment does extend to U.S. territories for purposes of citizenship, that they should be treated as equal. The 13th and 15th Amendment must extend to territories as well. The majority's interpretation gave Congress unlimited powers over territories, but the extent of Congress' powers are found in the Constitution. That was the argument that they were providing. They were saying that the powers do not grow when the domain over which the authority extends does. That the majority's opinion treats the government as treated and created by the states, not the people, and would give Congress unlimited power over commerce with the U.S. territories. That would be unconstitutional in itself, and that there was no authority for this unlimited power in the Constitution. That the Constitution was to be followed at all times, and when the territory is acquired, the Constitution becomes the supreme law of the land there as well. No power exists in any part of the government to determine otherwise. The appropriate way to deal with questions related to the expansion of the U.S. is by constitutional amendment, not by judicial interpretation. So that being said, because the dissenting opinion believed in equality and that all of the amendments that are important in the U.S. Constitution should extend to the citizens in territories, there was the argument that could have led to them being able to apply under Section 8 of Article 1. But that wasn't the case. The majority was under the Fuller Court, and the Fuller Court decided that because of their conservative views, they weren't going to interpret it that way. This is the court. The Chief Justice was Chief Justice Fuller, and one of his memorable quotes was when he said, "Do I understand the speaker? Thanks God for his ignorance." And an audience member said, "Well, yes, if you want to put it that way." And Fuller responded, "Then you have a great deal to be thankful for." Fuller was known for his religious interpretation of the Constitution. He was kind of the judge that attorneys understood that if they were able to make a religious appeal, they could probably get a win. He was appointed by President Cleveland in 1888, and he served as Chief Justice for the Supreme Court for his entire life. Fuller administered the oaths of 5 U.S. presidents, and his legacy in this codice consists of landmark cases that are still significant today. For example, he ruled in Plessy versus Ferguson in 1896 and coined the phrase separate but equal in his court opinion. He was the one that upheld that segregation was constitutional as long as it was equal. And as strange as it may sound, today he wouldn't be viewed as a constitutional activist, but back then his popularity was very high, and it remained high throughout the rest of his service. Next, we have John Marshall Harlan, appointed by President Rutherford Hayes to serve as an Associate Justice on the SCOTUS. Justice Harlan was a champion for civil rights, and his legacy consisted of advocating for equality. In the insular cases, Harlan demonstrated his anti-imperialist sentiments, arguing that the Constitution did not discriminate between the rights between citizens of the states and the residents of newly acquired territories. He was one of the justices that participated in writing the dissenting opinion. He was also a Republican. Henry Billings Brown was another Republican. However, he was appointed by Harrison in 1890, and Brown's legacy was built through his affirming decisions. During his time on the bench, Brown authored over 450 majority opinions. Brown also authored the opinion of the court in Delima v. Bidwell, one of the insular cases, and he considered the status of territories acquired by the U.S. The case in the final decision was that the revenue clauses in the Constitution extend only to the states, not to the U.S. territories. So as you can see, while both judges were of the same party, there was clearly a difference of opinion over this topic. Josiah David Brewer was the next Associate Justice, who was also a Republican and was appointed by President Harrison as well in 1899. Justice Brewer served as an Associate Justice for 20 years and became an important addition to the Fuller Court. His reputation consists of his unabashed religious beliefs while serving on the bench. This man was, like Fuller, he was a sucker for religious arguments. If they were able to have a religious appeal, Brewer would usually vote in their favor. Justice Shiras was appointed by President Harrison, who was also a Republican, in 1892. Justice Shiras went through a career without much excitement. He fulfilled his pledge of only sitting on the bench for 10 years, and in those 10 years, he voted with the majority of the infamous case of Plessy v. Ferguson. That was really his big case. Edmund Jackson was the first Democrat. Harrison appointed Jackson to fill a vacancy on the U.S. Supreme Court in 1893. Harrison's reasoning was that he saw in Jackson a former member of the Confederate government, not another sectionist Southern Democrat, but a man committed to serving his entire nation. Now, Rufus Wheeler Peckham was known for his strong use of substantive due process to invalidate regulations of business and property. Peckham's namesake father was also a lawyer and a judge and a representative. So he came from a family of political activity. Next, we have Associate Justice McKenna, and he was also a Republican, but he was the only justice appointed by President McKinley. He was appointed in 1898, and Justice McKenna was known for his legal reasoning. He understood that federal power was over man, states, and private businesses, and this would sometimes cause criticism. In the famous insular cases, McKenna agreed with the concurring opinion, at which he arrived by reasoning quite different from that of Justice Brown, speaking for the court that Puerto Rico had the status of an unincorporated territory, and hence, until so described by Congress, was not entitled to the equality of treatment as part of the metropolitan U.S. So I think that Justice McKenna here was probably the one that justified his argument the best. All of the other justices were really in for the U.S. being independent and how the U.S. is only constructed of the states, and they believed that because Puerto Rico was just a territory, their allegiance was to Puerto Rico and not the other way around. And here McKenna says that, yeah, if they were incorporated, then yeah, they should have the same rights. However, because they're unincorporated, they're not protected by the Constitution, and it's up for Congress to make a law like they did with the with the Louisiana Purchase in order to make that legal. Associate Justice Gray was appointed in 1881 by President Arthur. In his 21 years of service, Gray was distinguished for his broad knowledge of the court's previous decisions and the deft application of the precedent cases before him. In his concurrent opinion in Downs v. Bidwell, Congress, he said, should govern these latter territories as it is wished, subject to fundamental protections under the Constitution, those protecting individual liberties rather than those granting political participation. So Gray was well known for his application in the past, and I think that a lot of what came to his opinion was derived from other cases that have happened in the past in which they said that territories should be granted the same rights. So he had a little bit of both in his opinion. So as you can see, this was just the way Puerto Rico was viewed. They believed that, yeah, it was just Uncle Sam stepping on their land, not the other way around. It wasn't like they believed that there was some kind of allegiance from Puerto Rico or to Puerto Rico and to its citizens. They believed that all benefits were for the U.S. because they liberated Puerto Rico. So there was no reason to grant them more relief. So what does this mean? There's the phrase, the Constitution does not follow the flag. And what they meant by the Constitution does not follow the flag was that sometimes the Constitution can't be applied in all land belonging to the U.S. And because of that, many citizens were deprived of their rights. Today, Puerto Rico is a commonwealth, and that was because of President Truman in 1950 when he signed a law that allowed them to draft their own constitution and establish their own government. But before then, Puerto Rico was never really meant to have any sort of rights because, again, their allegiance was to the U.S. because they were liberated by the U.S. And that land was land that belonged to the U.S. And what this meant on an international stage was that the U.S. was finally becoming a world power, really. The ability to be able to liberate other countries and to obtain territories was the first step into what led to the U.S. becoming a superpower. The U.S. was a young country that was finally obtaining superpower status, and Downs versus Bidwell, as well as the rest of the insular cases, allowed for this to happen. By not allowing for Puerto Rico to be able to control their economics, the U.S. was able to obtain benefits as well as an authority status that, when looked by other countries, gave them this illusion of being the greater country. Downs specifically granted constitutional authorization to reach that status by interpreting Article 4, Section 3, Clause 2 of the Constitution, which is known as the Territorial Clause, to give Congress almost unfettered authority to deal with territorial possessions. And that was all. Thank you. Was that bad?
Yeah, that's good.
Okay. I mean, I can redo it. I wasn't dressed up today.
Okay, try to throw me under the bus.
Why is it making me wait outside? I'm not
Making me. All right. She down. Okay, everybody get a. Did you stop there?
Yeah, I saw it.
Okay, she ended.
No,
Okay, so everybody will get a. I appreciate you playing along. I appreciate we sometimes probably in the
Hey, you do what you gotta do to succeed.
And also, Terry,
I know.
Hey, you know a lot about the fact